The topic of my presentation today is biodiversity and traditional knowledge in intellectual property rights. In short, we can say that what is the role of intellectual property rights for the protection of biodiversity and traditional knowledge. Before going to the presentation, I would like to say that this topic biodiversity is very important for us for the net examination because it contains in three topics, in three subjects, that paper one, that is environment, people and environment, and second paper is our optional paper, environmental law, and in intellectual property rights also. So moving to the first slide, that is contents of my presentation, and then moving to the introduction part. What is biodiversity? Biodiversity is all the different kinds of life you will find in one area, the variety of animals, plants, fungi, and even microorganisms like bacteria that make up our natural world. Each of these species and organisms work together in ecosystems like to intricate web to maintain balance and support life. Biodiversity supports everything in nature that we need to survive: food, clean water, medicine, and shelter. In short, we can say that biodiversity is the combination of more microorganisms, plants, and animals in ecosystem. Microorganisms means bacteria, other fungus, virus, etc. The microorganisms, and plants and animals in the ecosystem. Biodiversity is the number of living organisms, both plants and animals, present in an ecosystem. Any loss happens in the food chain of the species. It means the breaking of all link of the sustainability of our biodiversity. So moving to the next slide. But as humans put increasing pressure on the planet using the consuming more resources than ever before, we risk upsetting the balance of ecosystems and losing biodiversity. WWF's 2020 Living Planet report found on an average 68% decline in global populations of mammals, fish, birds, reptiles, and amphibians since 1970. Here, WWF means the Worldwide Fund for Nature. The 2019 Landmark Global Assessment reported by the Intergovernmental Platform on Biodiversity and Ecosystem Services reported 1 million animal and plant species are now threatened with extinction, the highest number in human history. Biological diversity is the hallmark of life on Earth. It is very backbone of sustainable development. All of you know that what is sustainable development. Our economic growth should be balanced with the protection of our natural resources. We should protect our natural resources to our next generation, and we should be part of the development of our economic stability. Then the current intellectual property right, IPR regime, is encouraging commercialization of seed development, monoculture protection of new plant varieties, microorganisms, and genetically modified organisms. As a consequence, our rich biogenetic diversity is being eroded irreversibly. We must find out a path to make an alternative approach that will bring a balance in between formal intellectual property system and sustainable aspects of biodiversity. The next slide deals with history of the role of intellectual property rights in the area of biodiversity. The initial step towards making biodiversity a commodity evolved from the United Kingdom wanting to use high quality seeds of agricultural production. This slowly led to companies selling registered seeds. Later, the government rewarded individuals who improved seeds. Further, this led to the development of breeders. For over 60 years, different forms of protection on new plants varieties through system of PBR have in existence in industrialized countries. PBR means protection of biological resource. In 1961, the UPOV enacted. The full form of UPOV is International Union for the Protection of New Varieties of Plants, was established in Geneva for coordinating the inter-country implementation of PBR. The convention was signed in Paris in 1961. It was revised in Geneva in 1972, 1978, and 1991. The Act came into effect in 1981. In 1972, USA started patenting of genetically engineered bacterial strain. It was invented by famous microbiologist Dr. Anand Mohan Chakrabarty. He was an Indian origin. Then coming to the Indian scenario. India is one of the mega biodiverse countries with different combinations of ecosystem. The biodiversity or biological diversity of India occurs at three levels, namely species, genetic, and ecosystem. What is species? It is the most basic way to keep an account of biodiversity as it includes all forms of life, which means from the single cell organism such as amoeba, virus, to the multicellular organisms such as plants and animals. Then what is genetic? It refers the variation of genes in species. For an example, jasmine plant and rose plant is coming from a same species. But the genetic background of rose plant is entirely different from the jasmine flower and its plant. That is the point of genetic. Then moving to the next point, ecosystem. It differentiated between different habitats. For example, the forest ecosystem is entirely different from marine ecosystem, and desert ecosystem is entirely different from the both forest ecosystem and marine ecosystem. That is the important three levels of Indian scenario regarding biodiversity. India implemented Convention on Biological Diversity, CBD 1992. CBD is a United Nations Organization's Convention on Biological Diversity, and it is derived from as a signature treaty in Rio Summit, which was held in Rio de Janeiro at Brazil in 1992. So, being a party of that convention, India implemented or executed many objectives of CBD. On the basis of that, enacted Biological Diversity Act 2002. And there was an immense change happens in 2002 in the IPR regime of India. That is, microorganisms became patentable, whereas invention relating to traditional knowledge were included in the list of what are not invention in Patents Amendment Act 2002. Then definitions. Biological Diversity Act 2002 of India has defined biological diversity means the variability among living organisms from all sources and the ecological complexes of which they are part, and includes diversity within species or between species and of ecosystem under section 2 clause B. According to UNO, biodiversity is the variety of life on earth and the natural patterns it forms. Biological Diversity Act 2002 of India defined biological resources means plants, animals, and microorganisms or parts thereof their genetic material and byproducts with actual or potential use or value, but does not include human genetic material. Then internationally, regulatory framework on the role of IPR on biodiversity. The global push for privatization of biodiversity continues to encourage ownership over genetic resources. Many countries and the large business they support increasingly want to control these resources and the knowledge associated with them for commercial purposes. The means for such control is the use of intellectual property rights, particularly patents. Next, the important internationally regulatory framework is TRIPS, Trade Related Aspects of Intellectual Property Rights. The obligations under TRIPS can have adverse impact on the use of biological and genetic resources and the distribution of benefits arising therefrom. TRIPS agreement under 27.3 clause B provides that members may exclude animals and plants from patentability to microorganisms for products and microbiological and non-microbiological processes for plant and animal production must be subjected to patenting. TRIPS agreement supporting protection measure over each country's biodiversity through acknowledgement by the CBD. In simple way, we can say that under TRIPS agreement, biological and non-biological process for plant animal production, plant and animal production must be subjected to patent. It is patentable, but exclude animals and plants from the patentability. That is the simplest meaning of these points. And then Article 27.3 Clause B of TRIPS agreement grants members flexibility in the way they provide protection of plant varieties by offering options of either patents or sui generis system or combination of both. Here, it is a new term, that is sui generis. Uh, it is another way of patent. The meaning of sui generis is its own kind. A supplementary protection certificate, SPC, is a best example for the sui generis. It is also a IPR, intellectual property rights certificate like patent. And for an example, it's using for making medicines from drugs. Morphine medicine, it is a high quality painkiller, that is morphine and ultracid. These two medicines were making from drugs like opium. So this medicine should get the SPC certificate other than patent for the for entering to the market. Next slide is WTO, World Trade Organization. At the fourth WTO Ministerial Conference at Doha, China and G77 issued a statement which said the TRIPS agreement should be supportive of and not run counter to the objectives and principles of the CBD. UPO, it is an international agreement that sets rules similar to patents for monopoly rights over crop varieties. Several Asian countries already have or are in the process of making UPO-style laws for plant protection. Members of International Association of Seed Industry have continued to pressurize governments to adopt UPO. Then WIPO, World Intellectual Property Organization. As a part of WIPO ADR services for specific sectors, the WIPO Center provides dispute resolution advice to help parties resolve dispute arising in the area of biodiversity without the need for court litigation. Next point is Convention on Biodiversity. CBD is a binding treaty under Rio Summit held at Rio de Janeiro, Brazil, 1992. The CBD represents a dramatic step forward in the conservation of biological diversity, the sustainable use of its components, and fair and equitable sharing of benefits arising from the use of genetic resources. These are the three objectives of CBD. First one is conservation of biological diversity, second one is sustainable use of its components, and third one is fair and equitable sharing of benefits arising from the use of genetic resources. Under Article 8 Clause J, there is working group under CBD for studying existing system for handling and managing innovations at the local level and their relation to existing national and international system of intellectual property rights. And it's have two supplementary agreements, that's Nagoya Protocol and Cartagena Protocol. Nagoya Protocol aims at sharing the benefits arising from the utilization of genetic resources in a fair and equitable way, and Cartagena Protocol adopted in 29th January 2000 as a supplementary agreement to the CBD. Next is Food and Agriculture Organization, FOA. It provides a space for national recognition of farmers' rights. Then APEC, Asia Pacific Economic Cooperation, to solve issues associated with the genetic resources. Then UNO. The UNO has proclaimed 22nd May 1993 as the International Day for Biological Diversity. In 22nd May 2021, the theme was "We are part of the solution," and now in 22nd May 2022, the theme was "Building a Shared Future for All Life." Then the next point is what is traditional knowledge. Traditional knowledge includes types of knowledge about traditional technologies of subsistence, example, tools and techniques for hunting or agriculture, midwifery, ethnobotany, and ecological knowledge, traditional medicine, celestial navigation, craft skills, ethnoastronomy, climate, etc. Here, midwifery means the lady who assisting for childbirth, and ethnobotany means the scientific study of plants, and the celestial navigation means finding the way by observing sun and moon, and ethnoastronomy is the study of relative stars and planets. So, traditional knowledge is associated with biological resources, is an intangible component of the resource itself. TK has the potential of being translated into commercial benefits by providing leads for development of useful products and processes. But only new knowledge can be patented. Patents only apply to invention, not to existing knowledge. If a traditional knowledge is held only in a oral form, then IPR regime do not consider oral knowledge a proof of previous documentation, and therefore such knowledge is a danger for being patented. In short, we can say that to find out a exact definition for traditional knowledge is very difficult task, because traditional knowledge is coming from transferring from the one generation to another. So there was not a exact owner for this knowledge. And traditional knowledge is a byproduct of tradition and culture possessing by indigenous community or a class of people as a part of their livelihood of such people, and their circumstance and surroundings is based on this traditional knowledge. So this traditional knowledge should be protected, because it's very hard to protect from the commercial exploitation nowadays. International regulatory framework on the role of IPR on traditional knowledge. According to Article 8 Clause J of CBD, traditional knowledge acquired from experience gained over the centuries and adapted to the local culture is transmitted orally from generation to generation. WIPO, traditional knowledge and IPR are being brought together. WIPO defines traditional knowledge as the knowledge, skills, practices sustained and passed on from generation to generation within a community, often forming part of its cultural or spiritual identity. Then next point is example for traditional knowledge. It will become clear from this example that Jeevani is a restorative, immuno-enhancing, anti-stress and anti-fatigue agent based on the herbal medicinal plant Arogya Pacha, used by the Kani tribals in their traditional medicine. Within the Kani tribe, the customary rights to transfer and practice certain traditional medical knowledge or held by tribal healers known as Platis. The knowledge was divulged by 3 Kani tribal members to the Indian scientist who isolated 12 active compounds from Arogya Pacha, developed the drug Jeevani, and filed 2 patent applications on the drug and another for the plant for different use. Here, Jeevani is a tribal medicine. It's used by and taking by this medicine from plant Arogya Pacha, and the tribes Kani were using this plant, and they are using for as medicine by the tribal healers known as Platis. But the members of this tribal society transfer their secret of this medicine to the scientist, and they developed Jeevani and give application for the patent. The technology was then licensed to the Arya Vaidya Pharmacy, an Indian pharmaceutical manufacturer pursuing the commercialization of Ayurvedic herbal formulations. But then pharmaceutical patents were granted, which had to be revoked. Once the patented invention was combined with the teaching of traditional medicine, which is constituted relevant prior art. Relevant prior art means the evidence giving that your invention is already exist or already known. That is the meaning of prior art. So this medicine license is revoked by the government. And another example is US use of turmeric in wound healing, issued March 28, 1995. Turmeric, the scientific name of turmeric is Curcuma longa, is a plant of the ginger family yielding saffron colored raisins used as a spice for flavoring Indian cooking. Its unique properties also make it an effective ingredient in medicines, cosmetics, and as a color dye. As a medicine, it is traditionally used to heal wounds and rashes. In March 1995, two expatriate Indians at University of Mississippi Medical Center, Jackson, the name of those people are Suman K. Das and Harihar P. Kohli, were granted a US patent for turmeric to be used heal wounds. That is the second example. So, moving to the next slide, that traditional knowledge on biodiversity conservation. In order to be effective, efforts on biodiversity conservation can learn from the context, specific local knowledge, and institutional mechanisms such as cooperation and collective action, intergenerational transmission of knowledge, skills, and strategies. Traditional knowledge on biodiversity conservation in India is as diverse as 2,753 communities and their geographical distribution, farming strategies, food habits, subsistence strategies, and cultural traditions. In India, these systems can be classified in following ways: by religious traditions, example, temple forests, monastery forests, etc. Then traditional tribal traditions, for example, sacred forest, groves and trees. Royal tradition is next point. That example is royal hunting preserves, royal gardens. And livelihood traditions, cultural and social sources of livelihood, products and services. So today I winding up from this point, and the rest part will taken on tomorrow in the same time. Thank you.
Different news reported in the Hindu, which I consider it has a constitutional importance. And the second issue reported by the Hindu, which is I think is a constitutional